Well, thank you very much for the invitation to give a talk on my research over here. So in this particular research, I co-author with a former PhD student from HKUST who is currently in Xiamen University, and also my colleague in the accounting department, Amy. Now, this paper over here and the research question is focusing on the security class action lawsuit in the US. Now, what exactly is security class action lawsuit? Imagine that you are one of the investors. You bought a firm's shares. The firm did something wrong, and you want to sue the firm for compensation. Okay? Now, normally we think of when the firm does something wrong, we have the regulators penalizing the firms. An alternative channel, which is more prevalent in the United States, is that investors actually sue the firms. Now, one of the problems of having the investors sue the firm is that if you are an individual investor, you bought $30,000 of shares, and then you lose 20%, that's only $6,000. That's not enough to hire a lawyer. So what do? We band them together and band them into what we call a class. A class of investors can sue the firm at the same time. They're going to minimize the cost of legal fees because they can spread out the legal fees across all the investors and then sue the firm at the same time. Now, how prevalent is it and how costly it is for firms to be sued in a security class action lawsuit? Let's take a look at some of the numbers. So this is a number from economic consulting firm in the US, Cornerstone, which specializes in security class action lawsuits. Now, these are the settlement numbers, which means that these are the numbers that firms actually pay at the end of the lawsuit after they are getting sued by the investors. You can see that the numbers over here, it varies a bit. Every year, there are about 50 to 80 settlements that the firms actually pay. And how much did they pay? Billions of dollars. Now, the lowest number over here, 2014, you can see the firms pay $1.3 billion. The highest number over here is $6.8 billion. So it is a lot of money involved. For the firms, that's a huge cost. Now, in addition to the cost, when you're being named in a lawsuit, the CEOs and the CFO of the firm are under a lot of stress because there's a high uncertainty on how the lawsuit will end. So how long do these lawsuits last? Let's take a look at some of the numbers over here. So some of them last between 2 years, 2 to 3 years, 3 to 4 years, 4 to 5 years. Actually, a lot of the lawsuits over here end up costing more than 5 years of the firm's time before they actually settle. So these are the lawsuits that have last years of CEO's life. Actually, in one of my trips to the US, I went to Airbnb. I actually rented a home from someone who used to be a CFO of a publicly traded company. Now he's in Airbnb. He said one of the reasons that he didn't do the job and quit the job later on was being named in a security class action lawsuit. So there's one bit of anecdotal evidence on how costly these things are. Now, if you are saying that, OK, I'm not a US citizen, I'm not running a US company, am I safe from these type of lawsuits? You are not. Let's take a look. So these are the numbers that are, the gray bar over here are the number of lawsuits that's filed against US issuers. And the orange one over here are the number of lawsuits that are filed against firms that are outside of the United States, but traded in the United States, so in ADR, etc. You can see the number of trends over here. They're increasing over time. Actually, if you look at 2020, about 1/3 of the lawsuits are filed against firms that are not even in the US. So let's take a look at where those firms are coming from. If you look at the number here, so the green bar over here, this is Asia. This is Israel, Canada, European. Now, at the beginning of the sample period over here, 2016, very few lawsuits are filed against Asia firms. If you look at the end of the period, almost 1/3 or even more of the firms are located in Hong Kong. So they're headquartered in Hong Kong. So it's very costly. And it's not just against firms that operate in the US, but also against firms operate outside of the US. Now, let's take a look at what do you have to do to get sued. Are you innocent or are you guilty? You are thinking that, well, maybe I did nothing wrong, so I don't have to worry about it. Let's take a look. So these are the green bars over here are the number of settlements that the firm have paid with SEC investigation, with SEC actions. So these are the guilty ones that the regulators agree that the firm did something wrong. And the gray bars over here are the ones without SEC actions. So whatever the firm has done, the firm is not up to the level that the regulators think that they have done something wrong. So the majority of the firms actually are not sanctioned by the regulators. Okay? Now, let's take a look at what about the accounting numbers. Did they say their accounting number wrong? Did they restate their accounting number? Did they get investigated by GAAP violations, etc.? If you look at the number over here, actually quite a lot of them, the majority of them, don't even have accounting restatements. So they didn't even make a mistake that's material enough that they have to restate their accounting numbers. Now, why are these firms sued then? Let's take a look at the reason that these firms are being sued. So if you look at the numbers over here, about all of them, 99 to 100% of them, say that the plaintiff argued that the firm have misrepresented their financial statements. Okay, so you have done something wrong with your financial statements. And almost half of them say that the firm made some false forward-looking statements. Now, what are false forward-looking statements? Basically, you say something about what will happen in the future, and then it turned out to be wrong. Now, you can argue that this is false forward-looking statements, but nobody actually knows the future, right? So it could be that the firm make an optimistic disclosure about what they think would happen in the future, and it turned out to be wrong. So these are some of the reasons that firms are getting sued. Now, let's take a look at one example over here. And you can tell me whether you think this firm did something wrong or not. Now, this is a particularly interesting example. I followed this example actually when the case was going on. So let me go through the details here. Now, there's a pharmaceutical firm called KV Pharmaceutical. They acquired the right to a drug that's specifically designed to reduce the risk of preterm labor for at-risk pregnant women and saw exclusive sales rights from the FDA. So basically, they have to identify a particular drug that only target a very small subset of patients, and then they bought the right to do so. They bought the right to have exclusive right to sell this drug. And they obtained this right from the FDA 3 years later. The FDA granted a request, and KV Pharmaceutical announced that they are going to increase the price from $10 per dose to $1,500 per dose. 150 times increase. And they also make a disclosure. So this is the key disclosure over here. They said that FDA generally prohibit distribution of compound products. Means that the FDA is going to help me enforce others so that they cannot sell the drug at $10. I'm the only one who can sell it. So they basically corner the market with this particular drug over here. Now, you might think that, well, this is legal, this is kosher, but just like everywhere else, politics is not just about the law and regulations. So what happens is that the newspaper picks it up, the patients picks it up, the senators picks it up. Everybody's talking about how abusive these companies are. So what happened afterwards is that the FDA actually announced that in order to support access to this important drug, it will not enforce actions against other manufacturers. So basically, the FDA is saying that this is not good. This is bad. This is immoral. I'm going to ignore the law. Okay? Now, what happened afterwards is that the stock price, share price plummeted by 50% in the next 2 weeks. Shareholders file a lawsuit and say that the company did something wrong over here about the FDA prohibit distribution of genetic drugs. So shareholders filed a lawsuit. Now, this lawsuit, do you think that the company say something wrong or not? What do you think? Upa, what do you think?
Me?
Yes. Do you think that?
Freedom of speech.
Freedom of speech. The company said nothing wrong. You're sounding like Trump over here. Okay? Let's take a look. So the Court of Appeal actually dismissed the case. So the Court of Appeals of the 8th Circuit actually say that I agree that this is not a forced forward-looking statement. And the reason that they agree so is because the judges concluded that the forward-looking statement falls under the safe harbor provision. And what is the safe harbor provision? The KV Pharmaceutical Forms 10K, which is their annual statement, actually explicitly identify the risk that's associated with FDA's presumed enforcement of exclusivity. So if you look at the 10Ks, they disclose risk factors, which says that our future operating results may suffer if we fail to obtain and retain the expected exclusivity for this particular drug upon approval. So they say that, well, I'm saying that these things are right, these things, company shares is going to go through the roof because we're going to make a lot of money from it, but there is a chance that this couldn't happen if these things happen. So these are the risk factors that disclose. Now, as long as you disclose risk factors, it's fine. And that particular rule is called a safe harbor provision, which is passed in 1995. Now, the fun fact, the first case that actually used the safe harbor provision was actually used by Donald J. Trump. In the 1991 cases, that he opened a casino in Atlantic City, And the casino lost a lot of money, and investor, of course, sued him, and he's really good at lawsuit. He said, I told you so. I told you that many bad things could happen. And he was actually the first one. And that particular case law was made into law by the Congress in 1995 in the Private Security Litigation Reform Act of 1995. So this is the research setting that we look at. Once a firm discloses risk factors, they can pretty much say anything they want as long as follow under the roof of these risk factors about things that could go wrong. And even if they went wrong later on, the company wouldn't be held liable for these type of lawsuits. So the firms originally have a choice of whether to disclose risk factor or not. In 2005, the SEC actually passes a rule, which is the research setting of this study, that all the firms have to disclose risk factor. Okay? Now, when the SEC passed the rule of disclosing risk factor, they didn't think of this rule as safe harbor provision. They think of this rule as providing information about future risk that investors may suffer, that may be subject to if they invest in this particular company. So this rule, the intended purpose is to provide information about lawsuits. The unintended consequences, which we argue over here, is that firms actually feel more emboldened to make forward-looking disclosure because now they are making these risk factor disclosures. Okay? Now, how long are the risk factors? Risk factors are extremely long. If you open up a regular company's annual report, 1/6, so 1 out of every 6 sentences that you see in annual report, 16.5% are the risk factor disclosures. So the risk factors is going to provide a safe harbor provision. The SEC actually agrees with that in their analysis. The court have agreed with that. We have seen a case already. And the legal counsels are also involved in preparing the risk factor portion of annual report. Now, this is pretty big because usually who prepares the annual report? The accountants, the internal accountants, the external accountants, the auditors, etc. But now we have a legal counsel involved because they want to make sure that these risk factors can be used as safe harbor provision later on, subsequently. So what we argue in this paper is that safe harbor provision is going to lower the expected litigation costs. And by lowering the expected litigation costs, firms will be more willing to take forward-looking statements, take risk in disclosing forward-looking statements. Now, there's a big literature in economics on the risk compensation. So there are a couple of papers in the risk compensation literature. There's a paper in 1976 that looks at how people driving behavior changes once they have mandated wearing seatbelts. They find that people are more likely to drive faster, and there are more accidents, but smaller accidents, at least less injuries after this was imposed. And there's another paper that looks at when cyclists wear helmets, what are they going to do? They're going to ride faster, obviously. And there's a paper that looks at when banks are offered deposit insurances, when banks are guaranteed under deposit insurances, are they more likely to take risk? And the answer is also yes. So there's a big literature on that. And that's basically the story that we're trying to tell over here. Now, before 2005, before the Monday, firms can do anything they want. So some firms choose to disclose risk factors. Some firms do not disclose risk factors. When they're thinking about whether to disclose risk factors, every firm is going to go through a cost-benefit trade-off. They think about what is the cost of disclosing risk factors. Now, what is the cost? Well, you're going to disclose a lot of information about your firm, first of all. And second, investors are not going to like that because they see a lot of negative information when you disclose risk factors. And of course, there's a preparation cost and everything else. Now, what we argued here is that before 2005, there's a trade-off going on. After 2005, the cost is gone. It's not that the cost is completely gone for the firm, but because you're requiring firms to disclose, the cost becomes irrelevant in this case. It's like mandating everybody to buy insurance. Then you don't consider the cost of insurance anymore because you're going to assume that no matter what you do, you're going to have the insurance. This is out-of-pocket expense. We think of it as sunk cost, basically, right? So after this, are you more likely to disclose forward-looking statements and take risk in disclosing forward-looking statements? Let's go ahead and take a look. So we measure forward-looking statements using the MD&A disclosure the firm has. And that includes the sentences with some keywords that we identify from the MD&A. We look at how long the MD&A's portions in terms of forward-looking statements are. And we look at how positive these statements are. And that's our measure of how much risk the firm is willing to take when they're disclosing forward-looking statements. Now, we use a difference in different study. We compare the early risk factor disclosures with late risk factor disclosures. And then we also compare their trend before and after 2005, after they are required to disclose risk factors. Now, what we find over here is that for the early disclosures, the abnormal forward-looking statement length kind of decreases. You can see basically that there was a gap before 2005, and the gap narrows substantially after 2005, after firms are required to disclose risk factors. Now, we also went through some univariate tests in terms of statistical tests. Not going to bore you with the details over here, but basically we find the same thing here. So we find that after firms are required to disclose risk factors, they disclose more forward-looking statements, more positive forward-looking statements, and also just in terms of the length of the positive forward-looking statements also increases. So these are the definitive studies, definitive characters over here. Now, the other thing that we look at is also in terms of a regression. Now, in a regression, we're able to control for more variables that may be affiliated with the risk factor disclosures and also affiliated with forward-looking statements over here. So we run a regression with the forward-looking statement as the dependent variable. Of the independent variable, we look at whether a firm is a late risk factor disclosure, so they're disclosing because of the risk factor Monday. We look at the post periods, and then we look at some of the control variables, and we also control for industry and firm fixed effects to mitigate the influence of omitted-correlated variables that are associated with forward-looking statements. So we run a regression over here, and we find a positive results for all the specification that we look at. So firms are more likely to disclose forward-looking statements. They disclose longer forward-looking statements. They disclose more positive forward-looking statements. Now, in terms of the economic effect over here, we see that the late RF disclosures actually increases their forward-looking statements by about 67%. So that's a pretty substantial increase over here. Okay? Now, after the disclosure, they disclose about 2,479 words after the Monday, but before it was only 1,482. Now, if you look at the late RF, if you look at the ones that have always disclosed risk factors, it didn't change much. Before it's 2,300 words, now it's 2,600 words. So there's a little bit of increase, about 200 words over there. So basically, you can see that there's a big gap between before the risk factor Monday and after the risk factor Monday, there's a big catch up, and now they're not that different from each other. Okay? So this is the main result of the paper that we have. Let me see how much time I have. I still have a bit of time. So the next few things that we look at includes the management forecast. So we look at whether managers are more likely to make forecasts. When they make forecasts, what type of forecast do they make? Managers could say that our earnings is going to be between $1 and $3, or they could say that our earnings is going to be $1.5. So how precisely you want the forecast to be. We also look at how long the horizon is, right? Because if you look at a forecast about the next quarter, there's less uncertainty, you know what's going to happen, or a quarter that's ongoing right now. But if you want to make a management forecast about something that happened 3 years down the road, there's a very high uncertainty about something bad is going to happen, it's going to derail your plan. So we find that managers are more likely to make forecasts, they become more optimistic in making forecasts, they make more precise forecasts, and they make forecasts for a longer horizon after the risk factor Monday. So these risk factors really embolden the managers to make a lot more forward-looking forecasts and positive forward-looking forecasts compared to before. Okay. Now, in order to also see whether this result is actually driven by the litigation channel, we also look at which subset of firms are we expected to find higher results. So we look at two types of firms. First are the ones that are more likely to have wrong results. So their results are more likely to go wrong, so they're more likely to get sued. And the second are the firms that have been subject to judicial biases, which we measure with judge ideology. So we got two sets of measures over here. Firms that have higher volatility in their earnings are more likely to get something wrong because there's just more volatility in the operation, so more things are likely to go wrong. Firms that have higher R&D expenses are because R&D is highly uncertain compared to capital expenditure, something is likely going to go wrong. We also look at how competition. If you have high competition, again, you're more likely to get something wrong in terms of prediction. And lastly, we also look at judicial biases from the federal courts. And we find that across all the specifications, when firms are more likely to be subject to lawsuits, the effect of the risk factor Monday is stronger. Okay? That makes sense because if you are not subject to litigation risk, whether you are disclosing risk factor or not should not matter. So we find the results pretty much only in the firms that have high litigation risk. Now, the last thing that we look at is that if you look at the disclosure so far, we look at firms' action. Now, a firm, after making more disclosure, could either be informing the market or could be lying to the market. Right? Because there are two basic hypotheses over here. First is that whenever you disclose forward-looking statements, it provides new information to the market, so it should inform the market. But on the other hand, we are looking at a specific type of forward-looking statements, the type that are more likely to be sued by investors. So actually, if you look at the congressional record when they passed the law, the congressmen were very, very careful about the wording of the law. They are very concerned that if we provide safe harbor provision, companies are going to basically lie to their teeth to the investors because they don't worry about getting sued anymore. Actually, the original word over here is that a defendant's state of mind is irrelevant, meaning that it doesn't matter whether the defendant intend to cheat or not, as long as there is a meaningful cautionary statement, the risk factors, there are no liabilities, even if the defendant knowingly make a false projection. So there's high concern over here. Now, so we take a look at the results. Does this more forward-looking statements, do they actually benefit the investors or not? So we look at the capital market consequences. Specifically, we look at a couple of them. First, we look at the analysts, and second, we also look at the capital market benefits itself. Now, in terms of analysts, we find that analyst forecast error decreases. We find that analyst forecast dispersion decreases. So basically, analysts are forecasting a tighter range compared to before. So it seems like they're getting some information from the firms. Analysts are less likely to be wrong in their forecast, so their forecast error actually decreases. And we also find a decrease in the beta spread. So across all measures over here, we find that in addition to getting more forward-looking statement out there, the companies are actually taking advantage to inform the market instead of fooling the market, lying to the market itself. Now, we also look at whether the risk factors characteristics is going to affect the results. And over here, I'm not going to go through the details, but we find that the longer the risk factor it is, the more specific the risk factor it is, it seems like the result is stronger over there. And that makes sense because if you have made more specific risk factor disclosures, these risk factors are more likely to be deemed by the court to be valid for safe harbor provisions. Now, in terms of implications, I think that we have three implications over here that we want to talk about in this paper. First one is that disclosing risk factors is not only going to inform investors of information about risk, but also allows the companies, protects the companies from security class action lawsuits. So when you're making risk factor disclosures, in addition to thinking about what risk you are facing that you want to tell the company, also think about what other disclosure you are going to make and then tailor your risk factor to that. Second thing is that managers to tailor the risk factor to their own operation. You don't want to disclose something that's too generic. You don't want to just say that coronavirus is going to happen. You want to be very specific about how coronavirus is going to affect the operation of the firm. If you look at the actual case that we went through over here in the 8th Circuit about the KV Pharmaceutical, they are being extremely specific about what things could go wrong with their FDA approval, about specific drug that can affect their operations. If you just say that there will be regulations, regulation is uncertain, that is not sufficient. That's puffery talk. That's not going to be legally usable in the court. And lastly, the regulators, they should also think about what are some of the unintended consequences whenever they pass a law. There will always be intended consequences of the regulation and the law, and there will always be unintended consequences. So when you're trying to pass a law, or when you're trying to join a debate or legal debate about what's the pro and con of this specific regulations versus another one, think not just in terms of the intended consequences, but also what else could happen. How would it change other things? So we think that the paper also contributes to the regulatory debates on whether risk factor disclosure should be expanded or not. Okay. Now, with that, I conclude my talk. Thank you very much.
Thank you very much, Alan. Do we have any question from the audience for his talk? We can take maybe a quick question. Veronique?
Thank you. I'm a bit confused about where you say that there's no liability even if a defendant knowingly makes a false representation. So that means they can do write whatever they want and it protects them from lawsuits? I'm a little bit confused on that.
Yes, pretty much yes. For forward-looking statements only. It only protects them for forward-looking statements. If they give enough meaningful cautionary statements about what things could go wrong with the firm's operation going forward, that would turn this forward-looking statement into something that's wrong for the investors, yes, they're not liable.
But why do you say it incentivizes them to make false statements? I don't get the logic of that. I mean, you can make representations, but why would you make false representations? I don't understand the logic.
Because originally you could get sued if you say something wrong, and you could, for example, lie to the investors. Now your legal liability is gone because of the risk factors. So there are basically no cost to you of saying something that lie to the investors. So that's why we hypothesize that it might actually lead to managers lying more to the investors.
So I have a simple conceptual question. So suppose Dean Karyan Tam goes up and stands and says, I have a prediction that in 5 years from now, HKUST not only will be the best business school in Asia, but will be the best business school in the world. That's his forward-looking statement. But his legal counsel also puts in a risk factor saying, a lot of things may happen in the world in the next 5 years. So as a small retail rational investor, whatever Dean Karyan says is cheap talk. So why do investors react? And why is there information in this forward-looking statements anymore?
That's a very good question. I think that there are other costs for the firm for outright lying, right? Could be their reputation cost because it's a repetitive game. Most of the CEOs make not just one-time statements, they also make other statements in the future. So if you want your words to be believed, you probably should not lie all the time. At least you don't want to be caught lying and then you have to make some other talks in the future. So there's reputation cost to that. And second thing is that when the firms actually announce something, a lot of times they announcing something that's more specific than what you're saying. So for example, a lot of the ESG talks right now are not legally liable. Firms can make a lot of ESG talks right now, but if we look at the class action lawsuits, we have not seen even one class action lawsuit that are related to ESG cases that are successful. Because when firms say ESG, they just say that we will achieve net zero in 2050. Now, of course, it's very far in advance, or we'll become the industry leader in something. Those talks are not specific enough to become what we define as material for the investors. So when they're disclosing something that's more material, so it will be like our next quarter's earnings will be $4.50, or our production is going to increase by 67% next year. Something like that will be more specific. They are actionable by the investors, and these are the ones that are getting sued by the investors once they turn out to be wrong.
Thank you.